want to welcome everybody. My name's Maya Van Rossum. I'm the founder of the National Green Amendments for the Generations organization and movement. And I'm so pleased to be here with you this evening. And I'm pleased to be here with an auspicious panel of speakers. We are joined by Kacy Manahan, who's senior attorney with Green Amendments for the Generations and the Delaware Riverkeeper Network. Devin McDougall, who's a supervising senior attorney with Earthjustice. Devin Geyer, staff attorney for the Delaware Riverkeeper Network and Green Amendments for the Generations. And Shaylin Parker, who's an advocacy associate for Green Amendments for the Generations. And we're really pleased to be here with you this evening to be able to talk about the Pennsylvania Green Amendment and its important implications for government decision-making at the state level, at the local level, and within the regulatory agencies. We've allotted 90 minutes for this entire webinar, but in case there are some folks who have to leave early, we're going to do all of the presentations first, and then we're going to hold Q&A till the end. And that way the most number of people will be able to see the presentations, even those who might have to leave a little bit early for one reason or another. We're going to ask people, if you have questions, to use the Q&A function in order to preserve your questions. So as you think of them, pop them in the Q&A and we'll be able to pick them up at the end. And with that, I'm going to go ahead and just jump in and give a little bit of foundational information to help inform the evening. So the first thing I want to note is that over the course of this evening, you're going to hear people use one of three terms when talking about the constitutional environmental right here in the Commonwealth of Pennsylvania. Some people are going to use Article 1, Section 27. Some will use the Pennsylvania Environmental Rights Amendment, and others, like myself, will use the term Pennsylvania Green Amendment. All of these phrases refer to the exact same thing. They refer to the Constitutional Environmental Rights Amendment located in the Declaration of Rights section of the Pennsylvania Constitution. But that being said, why do I, for example, use the term Green Amendment? Why do we need another term other than Environmental Rights Amendment to refer to Pennsylvania's amendment? Well, we have this other terminology, the Pennsylvania Green Amendment, because the fact of the matter is there are many environmental rights amendments in state constitutions across our nation, as well as other constitutional provisions that talk about environmental protection in one form or another. But there are only 3 states that have an amendment that meet the Green Amendment definition, and as a result, give environmental rights highest constitutional standing, recognition, and protection. So it makes a difference. Every Green Amendment is an environmental rights amendment, but not every environmental rights amendment is a Green Amendment. So in broad strokes, what is a Green Amendment? A Green Amendment is carefully crafted language that meets certain essential identified criteria. Those criteria, you can find them on the greenamendment.org website or in the book, The Green Amendment, or in another talk, which is not this talk. But they are carefully identified essential criteria that are part of the Green Amendment definition. And that carefully crafted language that meets these criteria, when placed into the Declaration or Bill of Rights section of a state constitution, give highest constitutional recognition and protection to our environmental rights. And by virtue of that language, those criteria and the Bill of Rights Declaration of Rights placement ensure that our environmental rights have the same quality of protection that we give to the other cherished freedoms we hold dear, things like the right to free speech and freedom of religion. We all know how powerfully those cherished freedoms are protected because of carefully crafted language in our state and federal constitutions. Well, with the Green Amendment in place, we give that same quality of protection to our environmental rights. Now, as I noted, there are 3 states that already have Green Amendments: Pennsylvania, Montana, and most recently, the state of New York. Pennsylvania was actually the first state in the nation to secure a Green Amendment and have it added to its state constitution. The Pennsylvania Green Amendment was actually added to the state constitution in 1971. And it was added as the result of the vision of this wonderful gentleman, Pennsylvania Senator Franklin Curry, who recognized that if we wanted to give our environment and our environmental rights the same highest quality of legal protection that we give to the other human, civil, and political rights that we hold dear, we had to give it the same quality of protection within our state constitutions. And so it was Senator Franklin Curry that designed, developed, advanced, and secured the first Green Amendment in the nation. Now, while Pennsylvania's Green Amendment was added to the Constitution in 1971, in truth, it only really got its proper legal interpretation and its current legal vitality as the result of a landmark legal victory handed down by the Pennsylvania Supreme Court in December of 2013. It was that decision that literally breathed life into Pennsylvania's Green Amendment, which for the 4 decades before had been largely disregarded as simply a policy statement. Now, I'm very proud to say that it was my Delaware Riverkeeper Network organization, along with 7 municipalities, that crafted and advanced the legal arguments that won the day in December of 2013 with that powerful victory. This is actually Pennsylvania's Green Amendment language, and I want to highlight 4 elements of it that will be helpful as we go into tonight's presentations. The first is that the first sentence of the amendment recognizes that all the people of Pennsylvania have a right to clean air, pure water, and the preservation of the natural, scenic, and aesthetic values of the environment. This is an individual right of each person here in the Commonwealth of Pennsylvania. The next sentence recognizes that Pennsylvania's public natural resources are the common property of the people of Pennsylvania, including not just present generations, but all the future generations yet to come. And the final sentence of the amendment recognizes that government officials here within the Commonwealth of Pennsylvania are serving as trustee of these resources with the duty to conserve and maintain them for the benefit of the people of Pennsylvania, again, including future generations. And you're going to hear how powerful this language is as we go through tonight's presentations. Now, the result of this language is really threefold. It does recognize a right of the people that is meaningful and enforceable. It recognizes that government officials within the Commonwealth of Pennsylvania have a constitutional duty to protect the environmental rights of the people. But as valuable, it also creates a true opportunity, an opportunity for all government officials and all the people of Pennsylvania to better protect our environment and our environmental rights. It's not just an obligation and a right that we have here in Pennsylvania, but it is truly a positive opportunity to make a difference and to do better. By virtue of the language of the amendment and legal precedent, the constitutional obligation applies to all government officials in all 3 branches of government: the executive branch, the legislative branch, and the judicial branch. But it also applies to all levels of government. It applies to government officials at the state level and also at the local level. Now, I do just want to highlight one final thing. While Pennsylvania's 2013 landmark victory that we are so proud of provided critical protections to the people of Pennsylvania and literally breathed legal life into Pennsylvania's Green Amendment, it also served as the inspiration for my founding of the National Green Amendment movement back in 2014 that seeks to secure this most powerful constitutional protection in every state constitution across our nation and ultimately at the federal level. And so it's important for us to know that while we have 3 Green Amendments that are already in place, there are over 20 other states that are pursuing this most powerful protection. And every time we have a legal victory here in the Commonwealth of Pennsylvania, an advocacy victory, every time we have more clarity on our understanding of what it means to have a constitutional right to a clean, safe, and healthy environment, we are educating and inspiring all the communities working nationwide who are also seeking to secure this most powerful protection. So again, we are so pleased to have you with us here this evening. And with that, I am going to turn the podium over to Devin Geyer.
Awesome. Thank you, Maya. I'm just going to throw my slides up real quick. Okay. So, like Maya said, my name is Devin Geyer, and I'm a staff attorney for Green Amendments for the Generations and Delaware Riverkeeper Network. And my portion of the webinar will cover how the Pennsylvania Green Amendment works when it comes to legislative action. So I'll talk about some case law that has interpreted how the Green Amendment impacts the duties of the General Assembly, and also dive deeper into that case law that actually assessed whether or not certain statutory sections were constitutional under the Green Amendment. And then we'll do a little and quick review of standing for senators under the Green Amendment. So the first thing I wanted to address, even though most of this presentation won't discuss the first clause, because the case law that I'm going to talk about addresses the trust portion of the Green Amendment, it is still very relevant to the General Assembly's obligations under the Green Amendment, that the citizens have the right that is explained in the first clause. And this quote is from the Supreme Court decision in Pennsylvania Environmental Defense Foundation versus the Commonwealth, which I'll refer to as PEDF 2, from 2017. And it says that the rights of citizens to clean air and pure water and to the preservation of natural, scenic, historic, and aesthetic values of the environment places a limitation on the state's power to act contrary to this right. So although I'm not going to cover that a lot further, it is still relevant to what the General Assembly has the authority to do to actually comply with its obligations under the Green Amendment. And now I'll turn quickly to the standard of review that courts will use when reviewing challenges brought alleging violations of the trust portion of the Green Amendment. And the reason I want to explain this very quickly is so that it provides some hopefully helpful context as to what courts are looking for, especially in the cases that I'm going to discuss later on in this presentation, so that when I'm talking about certain words or duties, it's not the first time that hopefully you're hearing it. And so this is again from the same PEDF 2 case, and it states that the proper standard of judicial review lies in the text of Article 1, Section 27 itself, as well as the underlying principles of Pennsylvania trust law in effect at the time of its enactment. And so the reason that this is important to understand the case law that's coming is because the Commonwealth, and in this specific instance, the General Assembly, is a trustee and has fiduciary duties and obligations that it has to comply with in terms of the trust portion of the Green Amendment, as well as standards that govern a fiduciary's conduct, like the General Assembly. And this quote refers to the text of Article 1, Section 27, and the court in PEDF 2 explained that the explicit terms of the Green Amendment require the Commonwealth to conserve and maintain the corpus of the trust. And they also interpreted that to create a duty on the Commonwealth, and again, in this specific instance, the General Assembly, to prevent and remedy any degradation or depletion of public natural resources. And the second part of this is that the Green Amendment creates fiduciary duties on the General Assembly as its role as a trustee to act with the duty of prudence, duty of loyalty, and the duty of impartiality. And these are obligations and duties that the courts consider when assessing whether or not a legislative action is in violation or compliant with the Green Amendment. And so the duty of prudence, if you boil it down, means that the Commonwealth or the General Assembly has to exercise care and caution as if it was dealing with its own property and operating as it would if it were its own property. The duty of loyalty means that the General Assembly has to manage the trust to accomplish its purpose, as well as for the benefit of the beneficiaries, the people of Pennsylvania. And like I said a couple minutes ago, the trust purpose is to maintain and conserve the public natural resources. So that's where that obligation comes in. And then lastly, the duty of impartiality, which requires the General Assembly to manage the trust in consideration of all of the beneficiaries' interests, which, like Maya had said, includes both current and future generations. And going along with more of the obligations that are imposed on the General Assembly under the Green Amendment are these dual legislative action obligations that the Green Amendment creates. And this quote on your screen is from the Supreme Court of Pennsylvania in Robinson Township versus the Commonwealth that Maya had mentioned earlier and that Delaware Riverkeeper Network was a part of from 2013. And in this quote, it states that the Commonwealth has an obligation to refrain from performing its trustee duties respecting the environment unreasonably, including via legislative enactments. And even though that was a plurality opinion, again, in PEDF 2, the Supreme Court further affirmed that obligation for the General Assembly to not degrade or diminish or deplete the public natural resources. And in this quote, the court in PEDF 2 said that the Commonwealth has a duty to prohibit the degradation, diminution, and depletion of our public natural resources, whether these harms might result from direct state action or from the actions of private parties. So that's one of the first legislative action obligations, which is to refrain from degradation through legislative action of the trust. And then the second obligation is an affirmative obligation. And again, this quote is from the Robinson Township case. And it states that the second obligation peculiar to the trustee is, as the Commonwealth recognizes, to act affirmatively to protect the environment via legislative action. So this is the affirmative requirement that the General Assembly actually act to protect the environment. And like I said, even though that is a plurality opinion, the Supreme Court, again, in PEDF 2, affirmed this and stated that the Commonwealth must act affirmatively via legislative action to protect the environment. So in summary of those two Supreme Court cases that provide guidance as to what the General Assembly can and cannot do under the Green Amendment, we have these dual legislative action obligations, which is one, to take legislative action to protect the environment, and then also prohibits any legislative action that would degrade the trust. And so now I'm going to dive in to two cases that talk about whether certain statutory enactments and sections were constitutional under the Green Amendment, and also provide some of the analysis from the court broken down and the principles that we learned from those cases that guide any legislative action that the General Assembly can take. So in this first case, which is Robinson Township again, but it's a very important case, like Maya said, is a case where a party brought, or the parties brought several challenges against Act 13, which was a statutory amendment to the Pennsylvania Oil and Gas Act. And ultimately, in this case, the Supreme Court found several of the core provisions of the Act to be in violation of the Commonwealth's duties as a trustee. And so I'll go through each of those now and explain what that teaches us about the General Assembly under the Green Amendment. And so the first section was section 3303, which just boiling it down very generally, declared all environmental obligations related to the oil and gas industries to be a statewide concern, which then allowed, or what the Commonwealth believed it allowed them to do, was to preempt and exclude all local environmental legislation that could be perceived as having an effect on oil and gas operations. And the Supreme Court found this to be unconstitutional because it essentially demanded that the municipalities where these oil and gas developments would be taking place to ignore their Green Amendment obligations and then go a step further and take affirmative action to undo any existing protections that were in that municipality prior to the act. And the Supreme Court explained, and the guidance that it provides for action by the General Assembly are the two bullets on the screen, which is that the General Assembly cannot relieve municipalities of their Green Amendment obligations or remove municipal authority to fulfill Green Amendment obligations, because those are obligations that are delegated to the municipality through the Constitution, and so the legislature doesn't have the authority to take it away. In the next section that the court considered, which was section 3304, this, I'm going to very generalize this, it did a lot of things, but essentially allowed industrial oil and gas operations to be a permissible use in every zoning district, and that included residential, commercial, agricultural districts within a municipality, and also created a lot of problems if the municipality wanted to create any special conditions on those projects or tailor those projects to any localized environmental concerns that essentially did not allow any municipality to do that. And the court found that taking away that ability to tailor projects to the locality that they would be in, as well as allowing any project to go in any zoning district, was unconstitutional for two reasons. Because it permitted that activity in every zoning district, which the court meant it could not conserve or maintain the constitutionally protected aspects of that environment or the quality of life. And then also there would be disparate impacts for certain communities where they would have a higher level of environmental concerns than other communities or groups, and that the court found to be irreconcilable with the obligation of the Commonwealth to actually treat all of the beneficiaries or the people of the Commonwealth equitably in its management of the trust. And that goes back to one of the fiduciary duties that I talked about a few minutes ago. And this provided the bullets on the screen as to what the General Assembly cannot do under the Green Amendment, which is assess impacts to the Commonwealth's natural resources through a statewide average, or disregard local conditions while protecting environmental values. And then the last section of this case is 3215, which the court also found to be unconstitutional, but again, very general, broad description of what that section did was allow the Department of Environmental Protection to consider local concerns and conditions and requirements that were promulgated by the Environmental Quality Board, but didn't actually require the department to consider any of those things, and allowed the department to actually waive any setback requirements if the permit applicant submitted a plan to protect the waters of the Commonwealth. And this section was found to be unconstitutional for a multitude of reasons. But some of the main reasons are that it lacked identifiable and readily enforceable environmental standards for DEP to implement in order to protect the trust resources. And that meant that the section was in direct violation of the trust and its mandate to conserve and maintain the corpus of the trust. And it was, again, not responsive to local conditions like the previous section I had just talked about, and did not address local concerns. And again, also created a additional burden on the department and allocated any risky decision-making to the people, because the localities were not able to appeal any decisions, only industry and permit applicants were. So what the issues with this section taught about what the General Assembly cannot do is to dilute the Pennsylvania Department of Environmental Protection's authority to regulate and enforce adequate environmental standards. Going to the next case, which we had also talked about, PEDF2, this was a challenge in the Supreme Court to the 2009 fiscal code amendments, which specifically addressed money generated by the leasing of state forests and parklands for oil and gas development for Marcellus Shale. And again, the court ultimately found the two of the amendments that were reviewed in this specific case to be unconstitutional. And this one is a little bit more straightforward in that the court found it to be unconstitutional because it allowed the money that was generated by trust resources to be used for purposes other than the trust. And that provided the guidance that's on the screen here, which is that the General Assembly cannot divert proceeds from oil and gas development to a non-trust purpose without first considering and exercising its obligations as a trustee. And although these are a bunch of things that the General Assembly can't do, the courts did explain in Robinson Township what is a good example of legislative action in terms of the Green Amendment and what the General Assembly can do. And some of those examples are the Clean Streams Act, the Air Pollution Control Act, and the Solid Waste Management Act. And the bullets on your screen talk about, what a more general idea of a statute could do, which is define regulatory powers and duties, prohibit certain conduct, provide procedural safeguards, and also determine the standards of environmental protection. And this is from Robinson Township. And so the last thing I'm just going to quickly cover is that these two cases, Yaw v. DRBC and Muth v. DEP, both say in different circumstances that interference with the trustee's ability to administer the trust is not necessarily an injury that will reach the bar that is necessary for Article 3 standing, and that the Green Amendment does not grant special trustee standing to an individual legislator. So although these were different cases, they both essentially explain that just by being a trustee and just by feeling like your ability to fulfill your obligations as trustee is not enough of an injury to establish standing. So that is everything that I have, and I'll toss the presentation over.
Fantastic. And so next up is going to be Kacy Manahan. And while Kacy queues up her slides, I just want to remind everybody that if you do have questions, put them in the Q&A function and we will get them at the end.
Hi, everyone. My name is Kacy Manahan. I'm a senior attorney with Green Amendments for the Generations and Delaware Riverkeeper Network. My presentation, hopefully you can see my screen correctly, is about municipalities and the Green Amendment. So what is a municipality? the Pennsylvania Constitution actually defines that for us. It's a county, city, borough, incorporated town, township, or any similar general purpose unit of government which shall hereafter be created by the General Assembly. Municipalities often perform, they're kind of like miniature governments. They perform executive, legislative, and judicial functions, through hearings, through enforcement, and through the enaction of ordinances. They're often referred to in case law in Pennsylvania as creatures of statute that possess only such powers of government as are expressly granted to them and as are necessary to carry the same into effect. So what that really means is that all of the municipalities' authority derives from the General Assembly's authority, and that also means that all of the restrictions on municipalities, the constitutional restrictions such as the Green Amendment, are also derived from the restrictions on the General Assembly. So they are similarly restricted and empowered. There are also home rule municipalities, which have a slightly broader scope of ability to legislate. They don't need express statutory authority for each new ordinance. Their powers limited only by their home rule charter, the Pennsylvania Constitution, and laws from the General Assembly that preempt municipal action, that restrict them. So an example of a home rule municipality is the city of Philadelphia. This is pretty familiar now at this point, but obligations include the restriction to act contrary to the people's right in the first clause. So the municipalities cannot violate that right through unreasonable impairment. And then also the trustee duties, which includes the affirmative and prohibitory duties to conserve and maintain and to prevent and remedy the degradation of public natural resources. So I'm just going to run through some of the court cases that have so far addressed the role of municipalities in carrying out the Green Amendment. And so we'll start with that Robinson Township case that we've heard about, which was the section of that case that discussed the Green Amendment and its application was a plurality opinion, which the reasoning has essentially been adopted by the Pennsylvania Supreme Court in PEDF 2, which was a 2017 case. But I will say that there's although the reasoning and the framework and the interpretation of the Green Amendment has been adopted, not every little piece of Robinson Township has been taken and applied by a majority of the Supreme Court. So that's where you'll see some of these cases have a little bit of confusion about that. So the Robinson Township case was a challenge to Act 13. It prohibited local regulation of oil and gas operations, including via environmental legislation. It required statewide uniformity among the local zoning ordinances, and allowed gas drilling in all zoning districts, including residential. And as Devin mentioned, the court held that these localities, they have this constitutional obligation under the Green Amendment. The General Assembly can't relieve them of that obligation, and it cannot remove the implicitly necessary authority to comply with the Constitution. And the court also held that permitting industrial uses as a matter of right in every type of pre-existing zoning district is incapable of conserving or maintaining the constitutionally protected aspects of the public environment, which that's a very strong holding, saying like basically if you just put heavy industrial uses such as unconventional oil and gas drilling in every single district in a municipality, then that just doesn't work constitutionally. And then it also mentioned protection of environmental values is a quintessentially local issue that must be tailored to local conditions. And that has implications at all levels of government, but particularly for municipalities who have that kind of knowledge and authority to to protect the public natural resources and to protect the residents from overburdening and from specific environmental harms. And again, the court pointed out that the uniformity of Act 13 would essentially result in some communities being overburdened, right? Maybe they already are subject to intolerable environmental burdens. Maybe they're on the verge of that, and they would be pushed into a unconstitutional degree of degradation by this act. And it also, that in and of itself would be unconstitutional, but also the disparate effect is unconstitutional because the trustee needs to manage for the benefit of all the people and cannot sacrifice some of the beneficiaries for the benefit of others. And so this is a little diversion. I tried to put everything in chronological order just because that's usually how it makes sense in the development of case law. So the topic changes a little bit here, but this is an interesting case where a city ordinance restricted the installation of gas meters in a historic district, essentially, honestly, because they're a little bit ugly and they would ruin the vibe. So they tried to restrict where you could put the gas meters, and a gas utility challenged the ordinance and said, hey, this is preempted by the Public Utility Code and the Pennsylvania's Public Utility Commission regulations, which already provide where gas meters are supposed to go on buildings. And the Commonwealth Court agreed. They said, yeah, you are preempted. And, Article 1, Section 27, which would, normally addresses aesthetic and historic interests, doesn't immunize the local regulation from preemption. And so it read Robinson Township. This is the Commonwealth Court, by the way. So Robinson Township was a plurality. The section that we were discussing was a plurality opinion of the Pennsylvania Supreme Court. This is the Pennsylvania Commonwealth Court, which is a lower court. So they're bound typically by what the Pennsylvania Supreme Court says. But in this case, because it was a plurality opinion, that's basically a strong persuasive authority for them. They're not necessarily bound at this point by the exact words of that opinion. But this was also after the PEDF2 case was decided. So the new framework of Robinson Township was in place. But this is essentially the Commonwealth Court attempt at applying the rule that Robinson Township set out through their analysis of Act 13. And they said Article 1, Section 27 can bar preemption of local regulation where the state statute or regulation on which preemption is based so completely removes environmental protections that it violates the state's duties under that constitutional provision. The reason that preemption fails in such a case is that the preempting state law itself is unconstitutional. So the way that they're viewing this is that the state law, like Act 13 was, has to be so bad in that it ignored the local concerns of what the environment was like in each locality, that the statute itself has to be unconstitutional. Okay, and now we're back to oil and gas in residential districts. This was a 2018 case, again, before the Commonwealth Court. The rest of these cases that I have on here are all Commonwealth Court cases. So there hasn't been a lot of municipal action at the Supreme Court with regards to the Green Amendment since Robinson Township. So this case, Frederick versus Allegheny Township Zoning Hearing Board, was a challenge by community members to a zoning ordinance. So essentially the next few cases, some of these townships tried to do what the General Assembly tried to do with Act 13, but within their own township, right? They wanted to be friendly to the oil and gas industry. They wanted to encourage drilling in their town. So they said, hey, we're going to amend our zoning ordinances to allow you to be able to do this pretty much anywhere. And community members were obviously very concerned about that, and they challenged this ordinance, which also, this ordinance said that the applicant had to satisfy specific standards designed to protect public health, safety, and welfare before they could cite their oil and gas operations. And the community members argued that it failed to protect the public natural resources by allowing incompatible uses in environmentally sensitive areas such as agricultural zones. And here the Commonwealth Court created a rule, kind of. They just said this. This was not derived from the Supreme Court. They said, you know what? Judicial review of the government's action requires an evidentiary hearing to determine first whether the values in the first clause of the Environmental Rights Amendment are implicated, and second, whether the governmental action unreasonably impairs those values. And they also reiterated again in a footnote that unreasonable impairment will almost always require evidence, and that's why they mentioned an evidentiary hearing. But they affirmed that when municipalities enact their zoning ordinances, they are bound by the Environmental Rights Amendment and by all the other rights in Article 1 of the Pennsylvania Constitution. So that includes property rights, right? They have to consider both. And then they went into an analysis of the Oil and Gas Act, which was what the Act 13 had amended. Part of Act 13 was stricken because of the reasons in Robinson Township. But they essentially said a municipality may use its zoning powers only to regulate where mineral extraction takes place. A municipality does not regulate how the gas drilling will be done. They're saying that the Oil and Gas Act essentially preempts townships from basically describing the features of an oil and gas operation and saying you can, only emit this much and the details of how the operation takes place. They said that's the Oil and Gas Act. That's DEP. Townships don't have a say in that. They just have a say in zoning. Like, where do you put the operation? And then in this case, they said, well, the zoning board, when they were enacting this ordinance and when this ordinance was challenged by community members, there was a hearing. And at the hearing, there was a gas industry expert that said that oil and gas development can safely coexist with agricultural uses. And the zoning board believed that. They took that evidence and they said, okay, well then our ordinance is okay, and the Commonwealth Court upheld that determination. And here are a couple more cases along the same lines. Protect PT involved a challenge to a zoning ordinance that established new zoning districts and overlay districts that would allow fracking near residences. And that that ordinance had a provision that said, okay, applicants who want to cite their fracking operations in our town, you have to demonstrate that the drill site operation will not violate the Green Amendment in their application. So what that essentially did was shift the burden to the applicant to demonstrate compliance with the Green Amendment. But it's important to note that, although that it wasn't really tested in this case because there wasn't a specific application, if the applicant submitted an application, incorrectly concluded that its operations complied with the Green Amendment and the township just accepted that at face value, it's the township that's on the line. It's the municipality that's on the line for violating the Green Amendment. It's not the applicant. So, a challenge, as much as this ordinance may seem to be passing the buck can't actually be passed. So it's the responsibility of the municipality to comply with the Green Amendment. And then an interesting quote from this case is that it said that Robinson Township does not impose express duties on municipalities to enact specific affirmative measures to promote clean air, pure water, and the preservation of different values of the environment. And this was actually kind of a quote from the Frederick case that we discussed earlier. And that case described those specific affirmative measures as those that duplicate statewide environmental regulations. So that was a little bit more specific in Frederick. What we know from the Supreme Court has repeatedly said that Commonwealth entities such as municipalities do have an affirmative duty to protect the environment and protect the environmental rights that are in the Green Amendment. So this language here is a little bit confusing, but I think that what they essentially were trying to say was that they don't have, each township doesn't have to create its own DEP, right? Like you don't have to replicate every single thing that DEP already does or that statutes that regulate the environment already do. So again, that's confusing case law language and can be used in unfortunate ways. Another case that's unpublished, and an unpublished case generally means it doesn't have precedential force, but it is typically used persuasively by other courts. They will look to it, but it's not binding. So it was Murraysville Watch. Again, it was a challenge to an overlay district which allowed unconventional oil and gas operations in residential areas. And in this case, they said something interesting, which is that the Green Amendment does not require a township to engage in a pre-action environmental impact analysis, which we, just on face value, we also know that's not true. The Pennsylvania Supreme Court has said that the Commonwealth needs to consider environmental effects prior to acting. It seems that they kind of soften this later in the case, and they say, well, in enacting an unconventional oil and gas well ordinance, a municipality need only demonstrate, so there does have to be a demonstration, through the ordinance's design or some other form of evidence that it did consider the citizens' rights under the Environmental Rights Amendment. So I think what they were trying to say was that they didn't need to create an EIS prior to enacting an ordinance. And the EIS is something that is derived from, it's an environmental impact statement. It's derived from a federal statute called NEPA, and it's generally like a large document describing all the environmental impacts of a potential action. And I think that the court here was afraid that that's what the challengers were asking for in every instance of a municipality enacting an ordinance that affected public natural resources. But they're essentially saying there does need to be evidence that they considered the rights and resources protected by the Green Amendment. But the evidence doesn't have to be a specific document that was prepared. More recently, in Pfeiffer versus Coleraine Township Hearing Board, the Commonwealth Court evaluated the ability of a Chester Water Authority, which is a derivation of a municipal authority. It's a municipal authority that manages the water supply for Chester and other areas. And here the Coleraine Township Zoning Hearing Board had denied a special exception that would allow a CAFO, concentrated animal feeding operation. For those who don't know, CAFOs are really environmentally impactful, especially there's a lot of waste generated from the animals that are housed there. There's like tons and tons of animals just jam-packed in a warehouse or on a piece of land. And there's a lot of waste generated by those animals, and it often impacts water quality nearby. And so the Zoning Hearing Board actually denied this special exception. The CAFO folks appealed. Chester Water Authority wanted to intervene to protect their nearby reservoir. And the lower court had actually said, no, the Zoning Hearing Board already represents your interest because they denied it and they're not going to let it happen. So what are you even here for? And the Pennsylvania Commonwealth Court said, well, just because the Zoning Hearing Board also has a duty to protect the environment doesn't mean that the Chester Water Authority's duty is negated. And it also has a very specific interest in protecting its specific reservoir. So they allowed them to intervene. They also mentioned that, one of the reasons that they might deny intervention is because a court could say, well, you don't need to be in this case because if it goes sideways and it goes the way that you don't want it to, you'll still be able to get relief some other way. But they said, no, this is going to be an irreparable harm because post-contamination cleanup and damages. So like, for example, if it contaminates the reservoir, Chester Water Authority could go after the CAFO and say, you need to clean our reservoir, you need to compensate us for the water we had to source from somewhere else. They're saying that's not enough because the Green Amendment provides for anticipatory protection of the environment, and it's not just reactive cleanups. We need to allow Chester Water Authority to anticipate harm and to prevent that harm. Carnahan versus Slippery Rock. This was an asphalt plant that wanted to rezone an area of the township from rural conservation to light industrial so that they could do their asphalt operations. The township enacted the ordinance, community members appealed, and they argued that the ordinance benefited only the asphalt plant and failed to account for the environmental harms and the effect on public natural resources. The Commonwealth Court agreed with the zoning board that the asphalt plant was not treated differently from other surrounding parcels, so it wasn't a special spot zoning is what they call it. And that community members failed to present substantive or scientific evidence of environmental harm that may befall the area. And that's kind of harkens back to that earlier quote we saw about the evidentiary hearing needed to prove that there's a violation of the Green Amendment. And that the asphalt plant would, and they also said, well, anyway, the asphalt plant's going to, in the future, they're going to have to go through the special exception process, which includes an evaluation of the specific property's environmental impact. So there was more to be to be determined whether the impacts were so great that they would violate the Green Amendment. And then most recently, there's a case in regards to FDR Park. Some of you may have, if you follow Philadelphia news, FDR Park in South Philly is going through a major renovation involving the creation of some wetlands and also the creation of some and by the way, the wetlands are actually created in compensation for some wetland filling that's going to happen at the airport, but also the creation of some sports fields. And the area where the sports fields are going to be constructed was kind of an overgrown area that had been allowed to return to like a meadow and forested area. There were a lot of old growth trees, very large trees. And the plan is to not only just turn them into athletic fields, but astroturf covered athletic fields, so not a natural surface. There's also concerns about the astroturf containing PFAS, which are polyfluorinated chemicals that are pretty toxic. And then parking lots. And then these athletic fields would also be gated, so you couldn't just go and play on them whenever you wanted. You had to have like a reservation, things like that. So the neighbors challenged the decision to renovate that way. They went before the Orphans Court in Philadelphia, and the Orphans Court is not just for human orphans. It is for property that's held in trust. So that includes parklands. And the Donated and Dedicated Property Act says that if a city wants or a municipality wants to change the use of a property that was held in trust, then it needs to go before the Orphans Court and seek permission. And so the neighbors went to the Orphans Court. They said, hey, they didn't seek permission. They're just going to do this without any input. And the Orphans Court said, well, it's still going to be a park, so like get out of here. We don't have jurisdiction over this. So they appealed to the Commonwealth Court. And the Commonwealth Court says, actually, Orphans Court, you do have jurisdiction over public natural resources under the Green Amendment. And they also said that they need to review this change in use because it's changing the original trust purpose to a different trust purpose. It's a deviation from the original purpose of a public parkland. And then the Commonwealth Court, so they remanded to the Orphans Court to actually go through the Donated and Dedicated Property Act hearing process. And they said, by the way, when you're doing this, you need to read that act through the lens of the Green Amendment because it establishes the procedures for vindicating public trust principles, including those arising from the Environmental Rights Amendment. And that's true of pretty much every statute that touches on environmental issues. It needs to be read through the lens of the Green Amendment. There's something called, is kind of like a corollary of the constitutional avoidance doctrine, which is that courts, when they're reviewing statutes, they try to presume, they read it in the most charitable way to say like the General Assembly or the legislature must have meant to act in accordance with the Constitution. So we're not going to assume that they're violating the Constitution. This is kind of like the coin flip of that, which is that we're going to read the constitutional policy of protecting the public natural resources and the environment into the statute and assume that this was the General Assembly's way of doing that. And also, municipalities have used the Green Amendment in practice. So like not in a judicial, like not in a lawsuit, but in actually enacting ordinances and taking other specific actions, such as regulation of gas leaf blowers. In enacting ordinances that restrict or ban gas leaf blowers, municipalities have cited the Green Amendment, banning plastic bags and other single-use plastics, stormwater revisions to stormwater management, and the acquisition of property. So, for example, Marble Township acquired a parcel of woods that was possibly going to be developed, but it was really an area that was the only wooded area in a large residential and developed area. So they purchased that property to preserve it for the purpose of the Green Amendment and to preserve it as a public trust resource. There's also townships can affirmatively participate in litigation to protect environmental rights and public natural resources, kind of like we saw the Chester Water Authority doing. And in Robinson Township, a lot of those petitioners were townships. Marple Township has participated in litigation concerning the siting of some gas facilities that the PUC is attempting to site in that township. Bucks County sought to initiate a tort action against British Petroleum for climate damages. And then also it can be used by municipalities in denying land use applications. There's an example in Middletown Township in Delaware County where there was a warehouse application, and there's a lot of other reasons why that warehouse application was denied, but specifically in the denial, the township mentioned the Green Amendment and how the warehouse would increase traffic, which would increase air pollution due to the diesel emissions in an area that's already subject to air pollution. There would be noise pollution and light pollution, and that these levels of impacts would violate the Green Amendment. So what does it all mean? These are just some general principles that I think we can glean from what we've learned so far, which is that municipalities are unquestionably bound by the Green Amendment. They must act affirmatively to protect environmental rights and public natural resources using their existing statutory authority, because as the court said, they are creatures of statute. They're prohibited from violating environmental rights and violating their duties as trustee. And they're also in a unique position due to their ability to address local conditions and remedy disparate environmental impacts. So it's really an opportunity to look at things from that local perspective. As the plurality in Robinson Township said, environment is a quintessentially local issue. Not every stream is the same, not every neighborhood is the same, and municipalities have that unique position and perspective. Municipal action that affects Green Amendment rights and resources must demonstrate. So like ordinances, approvals, they have to demonstrate that somehow the municipality considered and complied with the Constitution. Municipalities must be aware of preemption as well as their own responsibilities to act affirmatively. So that's kind of, being aware of whether a certain type of regulation is preempted by a General Assembly statute, or whether there's like a gap that they need to step into and act affirmatively to protect the environment. And also that challenges to municipal actions and ordinances will ordinarily require an evidentiary hearing to prove the violation of the Green Amendment. So those are some of the takeaways. So I will hand it off to Devin McDougall for his section of the presentation.
So I'm here to talk about how the Environmental Rights Amendment affects Pennsylvania administrative agencies. And before I dig in, I do want to thank our hosts, Delaware, Riverkeeper Network, and Green Amendments for the Generations, for convening us and for providing me an opportunity to talk about this stuff, which I care a lot about, and it's very important. And I also want to thank you all for taking the time to learn and engage on such fundamental matters as our fundamental constitutional rights. So really appreciate everyone. And I'm going to try to be brief to leave time for Q&A. I've saw some great questions come up in the chat. Okay. So here's a little roadmap. I always like to do that. You'll see it a couple more times interspersed throughout the slides. I'm going to go over a framework first. Then we're going to go over a key point, which is that the ERA actually imposes both limits and duties on administrative agencies, and go through a case study of how that works, and how agencies have to exercise their statutory powers in a fashion that's consistent with the ERA. So an important part of the framework for the ERA is that it's forward-looking. It is designed to remedy failures in the past to ensure that those don't happen again. So when the Commonwealth faces, hypothetically, were it to be facing a global environmental crisis, threatening its public natural resources and the health and safety of its residents, the ERA would be a really important tool for getting the Commonwealth to take action on that threat. You see some of the history recited for the ERA in both Robinson Township and PDF2. So, Pennsylvania has been through waves of environmental catastrophes in the past, and the current iteration is climate change, and it's perhaps even more challenging than any of these. So that's the stakes of what we're up against. I like to use science fiction to think about how the law works and how it should work and how it can help us deal with some of these really pressing challenges like climate change. There's a lot of parallels. Science fiction concerns our choices, how they shape the future, and technology is really at the heart of it. And this is what our agencies need to be engaging with. How do they make choices about the technical infrastructure they build today, and how does that affect future generations? Something else that's really important to remember is that the ERA does chart a specific vision of the future, and that's a sustainable future. And that vision was democratically chosen by the people of Pennsylvania, 1971, unanimous at the General Assembly, 4-1 in the popular vote. And that's the course that we've chosen to chart for ourselves, and it's been incorporated into the fundamental rights section of the Constitution. And unless and until that's modified by another amendment, the Commonwealth's agencies that carry out the statutes and the duties that the General Assembly has delegated to them, they're bound to remain faithful to this vision. And so we're going to talk about how that actually works in practice. And here's some, pertinent quotes from PDF2. You can see that the Supreme Court has been very clear in its instructions to the Commonwealth and to Commonwealth agencies. You have to think about the future. And, it wasn't enough for the court to talk about a long timeline. They had to put an adverb in there to really make it clear to the Commonwealth. This is an incredibly long timeline. Okay, so this is not just one election cycle, which might be, what a lot of Commonwealth entities are focused on. That's the point of the Constitution. It forces you to think beyond the temporary time horizon that you might otherwise be focused on. So, agencies have a lot of power. Like Kacy mentioned, agencies also have a mix of roles, quasi-legislative, quasi-judicial functions, and they're considered structurally to be part of the executive branch. So it's not quite judge, jury, and executioner, but they do have quite a lot of power under one roof. And with that power comes a lot of responsibility, notably the obligation to exercise that power constitutionally, and that includes the ERA. So we're moving through the roadmap here. We're going to talk about some of those limits and duties. At a baseline level, the ERA is fundamental to everything that agencies do, in the sense that everything needs to be consistent with it. It's like the prime directive. And so you can think of the agencies, they're out there, they're like the ships of Starfleet, they're doing their missions, and they can't just say, oh, the ERA, that's the job of Starfleet headquarters. Not my problem. Don't have to think about it. Every ship's captain needs to be thinking about how am I complying with and giving meaning to the ERA. It's like a prime directive. And here's just some more legal language for you from PEDF 2. Again, the court is taking pains to be extremely clear. This applies to all agencies. Let's not get this confused. It's not any single branch. This is not the General Assembly's problem, and every agency can throw up their hands and say, they should be doing it, leave me alone. Every single entity of the Commonwealth has duties under the ERA. My co-panelists have talked about these. There's the rights clause, there's the trust clause, sharp limits on the power, duties on what you actually do as a trustee to steward those resources for future generations. The rights clause, I'll just, add a little color here. The way that works constitutionally is the Constitution has to give power to the General Assembly for it to do anything. And Article 1 accepts from that power. It's totally pulled out of that power once it's given to the General Assembly, the power to violate any of the rights in Article 1. So the General Assembly lacks the constitutional power to violate the ERA as well as the other fundamental rights. And what the General Assembly lacks the power to do, it cannot delegate to an agency to do. So agencies also at a fundamental level, that's sort of the molecular level of law, they lack the power to violate the ERA. And it's a basic constraint. The trust duties can be broken down into fiduciary duties, prudence, loyalty, and impartiality, and those can be broken down. It's it's beyond the scope of today, but there's a lot of interesting writing on that. The point that I'm going to focus on for the next few minutes is that agencies are wielding statutory powers. That's what they do. They have to act like a trustee. They need to be prudent. They need to be loyal, and they need to be impartial in how they use those powers. Whether those powers are specifically referring to or about the environment on their face, they need to be thinking about the environmental context for whatever they're doing. Okay, so now we're going to go through a little case study. As Kacy mentioned, agencies are creatures of statute. They are created by statute. So, it's a full circle. They exist in the world of statutes, but, that doesn't mean the Constitution is not important, because we have to interpret our statutes consistent with the Constitution. And, these are some holdings of the Supreme Court that really emphasize that when you're interpreting a statute, and, there's a possibility that you could interpret it one way and that would cause constitutional problems, and the other way would be consistent with the Constitution, you've got to interpret it the constitutional way. And, that's actually a really important point, because most statutes have more than one interpretation. That's what keeps lawyers busy. So if you're choosing between different interpretations, and, it's sort of an advocacy point, there's always a really good legal argument to support choosing the most environmentally protective possible interpretation of the statute, because we know that you have to interpret statutes consistent with the Constitution, and the ERA is part of the Constitution. So that argument is always there when we're contesting, state action, is to push them to interpret the statutes to really their fullest environmentally protective power. And as you'll see, that's come up in some cases. This is a case about what you might call the other ERA, the Equal Rights Amendment, which proscribes gender-based discrimination. And there's an issue with statutes that the insurance commissioner was administering. And the question was whether gender-based auto insurance rates are constitutional under the Equal Rights Amendment. And the applicable statute did not proscribe such rates. It didn't contain really any reference to them, but it did contain a reference to, discrimination not being permitted. And the Supreme Court said you have to read that together with the Equal Rights Amendment. And so this statute needs to be interpreted to ban gender-based discrimination in auto insurance rates. And that case is from 1984. It's a good early precedent for how the court is trying to show the agencies you have to interpret your statutes in a way that gives the fullest possible meaning to the Constitution. So as Kacy mentioned, a very recent case that actually applied the ERA specifically is FDR Park. The court, this is a Commonwealth court, emphasizing you have to interpret your statute through the lens of the ERA. So a little case study is the case of Marple Township. This is a case where my firm represented some clients along with John Dernbeck and Bobby McKinstry. And we were fortunate to have Delaware Riverkeeper Network and Green Amendments for the Generations in there on amicus, putting in some powerful briefs. And this case really had to do with what does the ERA mean for the PUC, specifically in how it administers this statute, Section 619, which is a statute that allows the PUC in limited circumstances to override a local zoning decision and allow utility infrastructure to be built over the objections of the municipality. And utilities can apply to the PUC and say, we really want you to exercise your power to force the municipality to allow this utility infrastructure. And the standard for that under this statute is that it needs to be shown that that would be consistent with the welfare and convenience of the public. So one of the issues raised by Marple Township and the citizens to this project at issue, which was a Pico gas substation to be located in Marple Township, the township and the citizens said, we're really concerned about the environmental impacts, and we think that that should be considered as part of the welfare of the public. And when you consider the environment, this project really doesn't make sense and it should not be allowed. And the PUC responded and they said, we don't have jurisdiction for that. We're not an environmental regulator. We're actually an economic regulator of utilities. Our job is to figure out rates. This statute doesn't say the word environment, and so we lack jurisdiction. We're not going to consider it. Marple Township brought it up on appeal, and the Commonwealth Court ruled that because of this principle of interpreting statutes in the lens of the fundamental rights of the Constitution, the PUC not only can it consider environmental impacts under this clause about convenience and welfare of the public, it has to. It has a duty as a trustee. And so this was a question that was teed up. Does this phrase include environmental considerations? And the court said yes. Now, that's not the end of the story. The fight is ongoing, unfortunately. On that second round, where the PUC was required to consider environmental considerations, the environmentalists in the case argued that has to include climate. So we have to consider the greenhouse gas impacts of expanding gas use in Delaware County. The PUC said, no, we don't. Their arguments were not super clear. It seemed to involve a lot of hand waving. And, as we pointed out, there's no asterisk on the Environmental Rights Amendment that says it applies to everything but climate change. There's no asterisk in Section 619. So what are we doing here? It's part of the environment. You have to consider it. PUC said basically, no, we don't. And we went to the Commonwealth Court. They regrettably decided to uphold the PUC order. So we are on appeal at the Supreme Court of Pennsylvania. We'll see where that goes. Wanted to invite folks, feel free to reach out if you have any questions, happy to chat. And I'll leave you with this final thought. The Commonwealth is how we live long and prosper together, or the ERA, how we as a Commonwealth live long and prosper together. So I'll stop there and
Great.
hand it back to
Thank
Maya.
you so much, Devin. And now we're going to hear from Shaylin Parker, because we have a new tool and resource that we've created at Green Amendments for the Generations to help municipal officials understand their obligations under the Green Amendment, but also to help advocates understand how they can use the Green Amendment to hold municipal officials accountable. Shaylin?
Thanks so much, Maya. Yeah, this will also be quick since it's an announcement like Maya just mentioned, but we are really excited to launch our Pennsylvania Green Amendment guide for Pennsylvania municipalities. It's a great complement to the presentations that you've heard today and speaks most specifically to some of the points that Kacy was making in her presentation. So our goal with this guide, and hopefully what you'll take away from it, is you'll understand more about local government's duty to respect the environmental rights of the people and to act as trustee of the state's natural resources, which we heard a bunch about this evening. We have some examples in there of what this means in action for government's day-to-day decision-making. And we also have many examples of how governments have relied on the Pennsylvania Green Amendment to protect our environment and environmental rights for present and future generations. So a lot of the cases that were spoken about today, you'll get some great summaries of them through this guide that will help not just municipal officials, but ideally will help local community leaders to get a better understanding of what their municipalities' obligations are in terms of Green Amendment. Like I said, it's a really great complement to today's presentation, and won't be quite as in-depth on some of the legal elements, but again, should serve as a really great general tool that you can refer back to in your daily advocacy. To talk a little more specifically about what's inside in the table of contents, first we run through the Pennsylvania Green Amendment, establish that baseline, talk a little bit about the language, as Maya did right at the top of this presentation, some of the key elements there that actually create these obligations for government. We talk about both government's duty to respect the environmental rights of the people and also their duty to act as trustee to protect the state's natural resources. And you'll see some of the duties that Devin mentioned reiterated in the guide. We've got a lot of examples of what this means in action for municipal governments, as well as actual steps municipalities can take to uphold their obligations. We'll also see how municipal governments have relied on green amendments to uphold environmental rights and fulfill trustee obligations. Like I mentioned, we have a great list of case law and advocacy examples that reinforce and set the pathway for these obligations set by the Pennsylvania Green Amendment and these opportunities set by the amendment as well. We also include in there some contact information, of course, if you read through the guide and you have any specific follow-up questions, then you can reach out to us. So I will be posting a link to this in the chat as well. But in case anybody has their phones handy, you can go ahead and scan this QR code in order to get your copy of the municipal guide. And we might also be adding a couple more links to that page it takes you to, as we've gotten so much great information from this presentation tonight. I'll also pop in the chat how you can reach out to us in case you or a group that you're interested or a group that you work with would be interested in obtaining physical copies of the guide or in a more personalized presentation on the Pennsylvania Green Amendment and its applications for municipalities. Lastly, I just want to flag for folks as we're talking about really pressing environmental issues of the time. We have another webinar coming up in a couple weeks on April 21st at 6 p.m., which will be all about how the Pennsylvania Green Amendment relates to data centers. So I will put the link to register for that event in the chat too, and we hope that we'll see you all there on April 21st. Thanks so much.